We are proceeding. This is the ruling of the court on the objections. Ruling on objection by Colonel Retired Dr. Chiza Besigye and another to be tried by General Court Martial. The two accused persons were brought before this court for pre-taking and raised objection on the ground that they are civilians and therefore cannot be tried by this court. In reply, Counsel Raphael Mujshala and Counsel for the State submitted that jurisdiction to try a person not otherwise subject to military law is provided under Section 117 of the UPDF Act. This court has looked at Section 117 G and H of the UPDF Act and finds that the accused persons are subject to military law. The objection is therefore overruled. We so rule. And listen to the charge sheet. The Republic of Uganda, Uganda People's Defense Forces, and the General Court Martial holding at Makinde, Kampala. Criminal case number UPDF /GCM /040 of 2024. A charge sheet. Uganda versus A1 ROV 0098, Colonel Retired Dr. Chiza Besigye, a male adult of sound mind, aged 67 years, resident of Kasangati Town, Nangawo Sub-County, Nansana Municipality, Waxo District, a person subject to military law by virtue of Section 117, subsection 1HI of the UPDF Act, cap 330. And A2 Haj Obeid Rutale, a male adult of sound mind, aged 65 years, a resident of Mutundo Village, Mutundo Parish, Makinde Sabagabo Sub-County, Busiro County, Waxo District, a person subject to military law by virtue of Section 117, subsection 1, HI of the UPDF Act, cap 330, are hereby charged with statement of offense on count 1. Offenses relating to security contrary to Section 128, subsection 1F of the UPDF Act, cap 330. Particulars of offense. Colonel Retired Dr. Chiza Besigye, Haj Obedia Rotale, and others still at large between October 2023 and November 2024, while in cities to wit Geneva in Switzerland, Athens in Greece, and Nairobi in Kenya, held meetings aimed at soliciting for logistical support and identifying military targets in Uganda with intent to prejudice the security of the defense forces. Colonel Retired Dr. Chiza Besigye, have you heard and understood the charge read to you on count 1?
I have.
Do you accept or you don't accept?
Don't.
A plea of not guilty entered. Haj Obedia Rotale, have you heard and understood the charge read to you on count 1?
Yes.
Do you accept or you don't accept?
I don't accept.
A plea of not guilty entered. Statement of offense on count 2. unlawful possession of firearms contrary to Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. Colonel retired Dr. Chiza Besigye Haj Obeidika Rotary on 16th November 2024 while at Riverside Apartments in Nairobi, Kenya, were found in an unlawful possession of a pistol model 27 KAL number 765, which is ordinarily the monopoly of the Defense Forces. Colonel Dr. Chiza Besigye, have you heard and understood the charge read to you on count 2?
I have.
Do you accept or you don't accept?
Don't.
A plea of not guilty entered on count 2. Haji Besigye Tali, have you heard and understood the charge read to you on count 2?
Yes.
Do you accept or you don't accept?
I don't.
A plea of not guilty entered on count 2. Count 3, statement of offense. Unlawful possession of firearms contrary to Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. Colonel retired Dr. Chiza Besigye Haj Obeidika Rotary on 16th November 2024 while at Riverside Apartments in Nairobi, Kenya, were found in an unlawful possession of a pistol HB 1014-1953, which is ordinarily the monopoly of the Defense Forces. Colonel retired Dr. Chiza Besigye, have you heard and understood the charge read to you on count 3?
I have.
Do you accept or you don't accept?
Don't.
A plea of not guilty entered. Haj Obeidika Rotary, have you heard and understood the charge read to you on count 3?
I have.
Do you accept or you don't accept?
I don't.
A plea of not guilty entered on count 3. Count 4, statement of offense. An unlawful possession of ammunition contrary to Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Particulars of offense. Colonel retired Dr. Chiza Besigye Haj Obeidika Rotary on 16th November 2024 while at Riverside Apartments in Nairobi, Kenya, were found in an unlawful possession of 08 rounds of pistol ammunition, which are ordinarily the monopoly of the Defense Forces. So, Colonel Dr. Chiza Besigye, have you heard and understood the charge read to you on count 4?
Yes, I have.
Do you accept or you don't accept?
Don't.
A plea of not guilty entered on count 4. Haj Obeidika Rotary, have you heard and understood the charge read to you on count 4?
I have.
Do you accept or you don't accept?
I don't.
A plea of not guilty entered.
Investigations are still ongoing. I pray that the accused persons be remanded. Accused person number 1 is the government prison, and accused person number 2 located at the government prison. And I pray that the case be adjourned for further mention on the 2nd of December 2024.
Confirm the date registrar. Huh? Which date?
2nd December. May it please you, Mr. Chairman and honorable members. My name is Lukwago, appearing together with the Wanda Martin, Ronald Samuel, and Bayani Frinawe. Mr. Chairman and honorable members, we are raising two objections, Mr. Chairman. One in regard to the order that has been issued regarding the remanding of the accused persons in separate facilities. We take exception to that. Mr. Chairman, they are jointly charged. As per the charge sheet, they were arrested together. They have been detained together. So it would be irrational, Mr. Chairman, and unreasonable to remand them in different facilities. In other words, there is no justifiable reason for them to be remanded separately. The justice of the case would demand that since they are jointly charged and they have to prepare a joint defense, they should be in the same facility where they can access their lawyers to effectively give instructions on how to manage this matter. It will be a great inconvenience to the accused persons and their lawyers to be in different facilities, Chitali and Ruzira, without having any point where they can converge and discuss their joint defense, because they are on one charge sheet. So in the interest of justice, we pray that the order be revisited and they should be remanded in one place. The most fundamental objection, Mr. Chairman, relates to the nature of the proceedings before this honorable court. And that is our second objection. Mr. Chairman, regards it's about the propriety of these proceedings before this honorable court. It's our strong contention, Mr. Chairman, that these proceedings are a nullity, considering the charges that have been preferred against the accused person. If I may be permitted to substantiate, Mr. Chairman, when you look at the particulars of all these 5 counts, 4 counts rather, they relate to offenses allegedly committed outside the jurisdiction of this honorable court. The first count talks about acts allegedly committed in Athens, Greece, Nairobi, and elsewhere. And Mr. Chairman, this honorable court has no jurisdiction whatsoever to deal with offenses allegedly committed in Greece, Kenya, and Switzerland. Mr. Chairman, that applies to count 2, which talks about Riverside apartment in Nairobi, where it's alleged that on the 16th of November this year, the accused persons were found in possession of a pistol, model 27 KAL number 765. And also count 3, which talks about the same place, Riverside apartment in Nairobi, Kenya. And count 4, the same place, which talks about ammunition. It's nowhere in these charges, there is nowhere in this charge sheet where it's alleged that all these acts, the impandi acts were committed within the jurisdiction of this honorable court, that is the territory of Uganda. Mr. Chairman, this court has got no universal jurisdiction for the entire world. That would be stretching the jurisdiction of this honorable court to levels of absurdity, that it can deal with any matter that is alleged to have been done, or any act or offense that is alleged to have been committed anywhere in the world. I would refer you, Mr. Chairman, to the provisions of Article 28, Clause 7, which provides that no person shall be charged with or convicted of a criminal offense which is founded on an act or omission that did not, at the time it took place, constitute a criminal offense. So in this particular case, Mr. Chairman, all the acts referred to here in this charge sheet, or highlighted in this charge sheet, do not constitute criminal offenses within the meaning of the laws of Uganda. Because the UPDF Act applies to Uganda and doesn't apply anywhere else. The boundaries of its application, the boundaries of the UPDF Act, are the confines of the territory of Uganda. It does not extend to Kenya, neither does it extend to Switzerland or Geneva. It is not a law applicable there. It's the reason here, Mr. Chairman, in the charge sheet, which we find to be incurably defective, it does not make reference to the laws of those respective countries where these acts are alleged to have been committed. Unlawful possession of firearms, contrary to Section 4, subsection 1 and 2 of the Firearms Act, Cap 320. Firearms Act of which country? Because we are talking about here Riverside, Kenya. And in law, this is considered to be a duplex charge sheet, which is ambiguous in nature. So the accused persons cannot understand the nature of the particulars of the charge sheet as they are spelled out in these particular counts. Because, Mr. Chairman, you are talking about Firearms Act of which country? Then we are talking about in County 4 on 16th of November 2024, while at Riverside Apartments in Nairobi, Kenya, Colonel Dr. Chiza Besigye and Haji Obedi Rutale were found in unlawful possession of 8 rounds of pistol ammunition, which are ordinarily the monopoly of the defense forces. Of which country? Because we are talking about Riverside Apartment in Kenya. Are they a monopoly of the UPDF or KDF? In which case, this would determine the nature of the pulley given by the accused persons as to whether the acts amount to an offense or not. So this is a defective charge sheet, Mr. Chairman, which should not sustain any criminal proceedings before this honorable tribunal. Lastly, Mr. Chairman, in Count 1, offences relating to security, contrary to Section 128(1)(f) of the UPDF Act, we presume this is Uganda People's Defence Forces Act of Uganda. That is the presumption, a rebuttable one, depending on the evidence given by whoever is preferring this charge. But we presume that they meant the forces of Uganda. This is again an absurdity, Mr. Chairman. Because when you talk about acts under the particulars of the offense, which relate to acts allegedly committed in Geneva, Switzerland, Athens in Greece, and in Nairobi in Kenya, and you relate them to the UPDF Act of Uganda, it's a nullity from the word go. So, Mr. Chairman, it's our prayer that this honorable tribunal be pleased to dismiss the charge sheet, rather, no, sorry, to strike out, sorry, Mr. Chairman, it's our prayer, Mr. Chairman, that this honorable tribunal be pleased to strike out this charge sheet and accordingly discharge the accused persons, because as far as this charge sheet is concerned, there are no cases that should be preferred against them within the laws of the Republic of Uganda. Finally, Mr. Chairman, the accused persons have been illegally presented before you, Mr. Chairman. The two accused persons here traveled to Nairobi lawfully for a legitimate activity, which was never in any way questioned by the security agencies and were cleared by the immigration authorities of Uganda. So they have been in Kenya lawfully, or they entered Kenya lawfully. And Mr. Chairman, once you are in a foreign territory, you can only be returned forcibly through the due process of the law. If you do not return voluntarily, and there are forces compelling you to return, they have to follow the due process. And there are only two ways under the law. Either extradition, that is under the Extradition Act of Uganda, or deportation. In which case, Mr. Chairman, if it's about extradition, it has to be upon a request of the Minister for Foreign Affairs that they are facing charges in Uganda here, and they are fugitives in Kenya, and they are demanding for assistance of the neighboring country to repatriate them back. We are not advised, it's not anywhere on record, Mr. Chairman, that that has happened. It's not on record. If you are to be a deportation, it presupposes that they entered the country illegally, or having entered Kenya legally, they committed offenses in Kenya. Again, it would be the authorities in Kenya to handle that. And they have to go through the judicial process in Kenya. Deportation has to be by a court order given by the Kenyan authorities, Kenyan courts of law. So in this particular case, Mr. Chairman, the record does not bring out those facts, that they were either extradited or deported. And according to Mr. Chairman, the Human Rights Enforcement Act of Uganda, once proceedings are rooted in a nullity, Mr. Chairman, this honorable tribunal has no choice but to terminate the same. It's our contention, Mr. Chairman, that the accused persons have been illegally produced before you. They have not been repatriated, rather deported, neither have they been extradited. And if anything, Mr. Chairman, they have not even gone through the immigration back here. As we stand today, they are presumed to be in Nairobi, in Kenya. The law presumes that they are still in Kenya. It would be a very, very absurd situation, Mr. Chairman, for this honorable court to sit here to handle cases or matters involving the two individuals who are currently standing in Nairobi. In the dock where they are standing here, the law presumes that they are in Nairobi, and the court is sitting in Uganda. So, Mr. Chairman, that is an absurdity which cannot be condoned by this honorable court, honorable tribunal. So on those grounds, Mr. Chairman, we pray that you be pleased to strike out to the charge sheet, dismiss the case, set the accused persons free unconditionally, and have them discharged. We do so, pray, Mr. Chairman.
Chairman and honorable court members, jurisdiction is a creature of statute. And section 208 of Uganda People's Defense Forces Act, which is an act of parliament, states a person alleged to have committed a service offense may be charged or dealt with and tried under military law, whether the alleged offense was committed in Uganda or out of Uganda. So to say that an offense which was committed in Athens, Nairobi, and that section resolves that. My Lord Chairman and honorable members, on the issue of extradition, that one can be addressed at it will be addressed. It can be his defense, and it should not be addressed at this stage. What is the evidence which has been produced before this honorable court that retired Colonel Dr. Chiza Besigye is supposed to be in Nairobi? That evidence has not been available before this honorable court. You are acting, you are submitting on speculation. So, we pray that counsel be overruled and his prayer be dismissed. All those are rotating on his jurisdiction. The offense is committed in Nairobi, so I didn't want to go in it, but the whole thing is rotating on the jurisdiction, whether an offense was committed in Uganda or not. And this section of the law addresses it.
Councillor Lukwago, do you have any rejoinder to that?
Yes, Mr. Chairman. One is objecting on grounds that the UPDF Act provides for service offenses to be tried by this honorable tribunal, whether committed here in Uganda or elsewhere. Mr. Chairman, the operative phrase here is service offense. And in this particular case, we're not talking about a service offense. Service offense under the UPDF Act means, in the definition section, an offense under this act or any other act for the time being in force committed by a person while subject to military law. Mr. Chairman, in this particular case, they are talking about, the law talks about an officer or a member of UPDF who is in actual service. Literally, that's what it means. It's a service offense. And it's on record, it's not in dispute that the accused persons are not members of the UPDF, Therefore, they are not amenable to charges of that nature, which are service offences. Mr. Chairman, the other argument is neither here nor there. And it's indeed really vague that it can only be raised in a defense. Mr. Chairman, it is the prosecution to make out its case. Sufficient particulars must be given, warranting the accused person to be put to their defense. So we are at a stage where the state must bring these facts before this honorable tribunal, before we talk about the defense. It is the UPDF that is charging the accused persons. It is the same institution that presumably arrested them. And that's a fact. So it would be, again, very unreasonable for the prosecution to ever imagine that actually the onus is on the accused persons to bring evidence regarding their arrest. It would be very, very unreasonable. When actually it is the UPDF, under the UPDF Act, which has this tribunal, and they are the ones prosecuting the accused persons before this tribunal. They are the ones who arrested them, and they are the ones who are supposed to bring this evidence. So the presumption is that actually the tribunal has these facts, because it's an integral part, the tribunal is an integral part of the institution of the UPDF, which presumably is the one which conducted the arrest, and I call it arrest in quotes, advisedly, because the accused did not bring themselves before this honorable tribunal. They were compelled by the UPDF. So, we are not obliged at this material time, Mr. Chairman, to adduce the kind of evidence he is talking about. Again, the rest of the issues have not been rebutted. We have raised a return of objections, and we are not surprised that they have not responded. They have not rebutted the same. We pray that Mr. Chairman, you take them as facts, and you take them as uncontroverted prayers, which ordinarily should be granted. We reiterate our earlier prayer that you be pleased to strike out the charge sheet, because all our objections in regard to the duplicity and the illegality of the charge sheet have not been controverted. They have not been rebutted. So they remain unchallenged. And there is a wealth of authorities that once matters are unrebutted, they are taken for what they are as matters of fact, which should be accepted by court and a decision made accordingly. So we pray that your worship, Mr. Chairman, you grant our prayers that we earlier on made. We do so pray.
Maybe, sir, you didn't respond to the point of being remanded in different places. Do you have a reason? Because I think they have argued their case, they are charged together, they were arrested together. You didn't even talk about it. Why are you applying that they have to be separated on remand?
We leave it to court.
So maybe, sir, having heard from both sides, the state and the lawyers for the accused, I think ordinarily the law requires that objection to the charge must be taken before a plea. And the Counsel Lukwago has raised the matter after the accused have pleaded to the charges. And this court is unable to give a ruling on these matters now. So I advise that they can be remanded and the ruling of court will be given on the next hearing date. Then the issue of remand, I think the court can consider the prayer made by Council Lukwago.
Yeah, Council Lukwago, your submissions have been taken seriously, and the court is adjourned to 2nd December 2024 for mention and ruling on what you have submitted on. And both of you, the accused persons, you are hereby remanded to the government prison.
Mr. Chairman, we needed a copy of the charge sheet, the signed charge sheet. Sign the copy. Photocopy of the charge sheet.